Good morning. Are you Stephanie Martin?
Yes, ma'am.
Give me just a second, please. Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
All right, Ms. Martin, and cause number 20. Let's see where am I start? Which one's being dismissed?
It's ending in 247, Judge.
And cause number 24, DCCR 0248. You're charged with the state jail felony offense of possession of a controlled substance from October 1st of 2023. The indictment alleges that you were previously convicted of possession of a controlled substance August 24th of 2015. And then after that was final, you were convicted of possession of a controlled substance April 11th of 2016, and also convicted of fraudulent use of identifying information on April 11th of 2016. And how do you plead to that charge?
Guilty.
And are those prior offenses true?
Yes, ma'am.
And then in cause number 23, DCCR 1850, you're charged also with the state jail felony offense of theft with previous convictions. Well, not also, but in that case, that's what you're charged with. And that's from July 14th of 2023. The indictment alleges you were previously convicted of theft August 14th of 2001, March 15th of 2006, September 8th of 2014, August 24th of 2015, April 11th of 2016, July 31st of 2018, January 28th of 2019, and then the indictment alleges those three prior other offenses of the possession of a controlled substance in two cases and that fraudulent use of identifying information. And how do you plead to that charge?
Guilty.
And are all of those prior convictions true?
Yes, ma'am.
In cause number 250376, you're charged with the state jail felony offense of theft of property with previous convictions. This offense date is from February 7th of 2025. It alleges all of those same prior theft offenses as well as the same prior state jail felony offenses. And how do you plead to that charge?
Guilty.
And again, are those prior convictions true?
Yes, ma'am.
And then finally, in cause number 250375, you're charged with the state jail felony offense of theft with previous theft convictions, and this is from February 18th of 2025. It also alleges all of those same prior theft cases as well as those other prior state jail felony cases, convictions. And how do you plead to that charge?
Guilty.
And again, are all of those prior convictions true?
Yes, ma'am.
In each of these cases, did you enter your pleas of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty in each case because you actually did what they've charged you with?
Yes, ma'am.
In all of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Martin is not competent?
No, Your Honor.
All right, Ms. Martin, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 250375, find sorry, okay. And 0735, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with prior convictions. Find all of the prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 250376, also find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions. Find all of the previous convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 23, DCCR 1850, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions. Find all those prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit for that on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24, DCCR 0248, also find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find all of those prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will all run concurrently, which means together at the same time.
So are we doing all this?
All of it runs at the same time, yes ma'am. I will also sign a dismissal in 24 DCCR 0247 as part of that agreement.
Your Honor, if I may, I'm sorry.
Yes, sir.
The plea also contemplates the declination of prosecution of the unfiled possession of a controlled substance that appears in BPD number 20250029990.
So the state has also, as part of this agreement, agreed not to pursue that specific case. Do you understand? So there's another possession case out there that Beaumont PD has, but that they haven't, either the labs haven't been done or whatever, it hasn't been indicted yet. What they're saying is they're not going to pursue that case. So it will not be indicted. You're not going to have to come back here and take care of that case. It's kind of like it's being dismissed before it really gets indicted. Does that make sense?
Yes, ma'am.
Okay. Did I print all 4?
Yes.
All right, so I'm going to hand you in all 4 of these cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishments I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Yes, ma'am.
I'm sorry, Ms. Rucker. Can I say one? Those are my kids right there. Can I just tell them bye?
From here, yes,
I'm
ma'am.
sorry I let y'all down. And I will see y'all when I come home, okay? You good. I love you, miss. My birthday tomorrow. I love you.
So, Ms. St. Clair, the thing to do is to take advantage of any opportunity you have while you're in custody so that when you do get out, you can be a part of their lives, okay?
Yes, ma'am.
All right.
See y'all in 2.5.
That's Jacqueline, yes. All right, good morning. Are you Tyron Henderson? And will your client waive the formal reading of the motions and the indictment?
Yes, Your Honor.
Just a second. Oh, God, hold on, I'm pulled up the wrong one. Go paperless, they said.
I remember in the old days, we just voted on.
I would have already been done.
Yeah.
All right, Mr. Henderson, in cause number 25 DCCR 0520, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from March 23rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rennick? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for a 10-year term in prison, but that would be probated for 10 years. Is that your, and it would run...
That's an error, Judge. That's an.
There's no
NPR.
concurrently,
Yeah,
okay.
there's no.
So, I'm gonna make that, mark
Yeah,
that out.
was my mistake.
And then I guess the agreement then on the others is to continue probation.
With ISF cognitive. That was actually all of the judge.
Okay. Oh, this one as well.
Yes.
Can I make that
Yes,
notation?
please, Judge. I apologize. About
So the agreement is also, if I follow it, that you would enter and successfully complete the cognitive track of the ISF program. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Henderson is not competent?
No, Your Honor.
All right, Mr. Henderson, in 250520, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. I am going to reset your case for sentencing. I want to get some more information about what's been going on and get an updated pre-sentence report, find out more information about this case and also what's been going on probation, and we'll come back later for sentencing. And can you double check? I don't see any, so I'm assuming there weren't any. If you didn't give it to me yesterday. It's perfect. We'll talk about that in a second. All right, then, Mr. Henderson, in cause number 2138934, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation August 1st of 2022 for the offense of evading arrest with a vehicle, and that was a 5-year deferred probation. Is that correct? Answer out loud, okay? And then in cause number 2239131, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 1st of 2022 for the state jail felony offense of unauthorized use of a vehicle. That was also a 5-year deferred probation. Is that correct? And then finally in 230899, I have a motion to revoke your community supervision. This shows that you were placed on probation November 27th of 2023 for theft of a property, state jail felony, and that was a 2-year term in the state jail prison, probated for 5 years. Is that correct?
Yes.
Each of these motions allege that you violated your probation. Count 1, and each of these motions allege that you were arrested for the offense of evading arrest or detention with a vehicle March 23rd of 2025. And is that true or not true? Count 2 alleges that you were arrested for the offense of reckless driving March 23rd of 2025. And is that true or not true? Count 3 alleges that you have not provided verification of performing the community service hours as required. Is that true or not true? Count 4 alleges that you were at a location other than your residence at approximately 3:35 a.m. March 23rd of 2025. And is that true or not true?
True.
Judge, that's sufficient for this now.
I think I'm going to keep going. I've got some concerns on this. Count 5, thank you though. Count 5 alleges that you did not provide verification of complete, well, hold on a second. Count 5, oh, they're different. Count 4 in 2 of the cases and count 5 in the other alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
It's
And then count 6 in each case alleges you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1 through 6 in each of these motions freely and voluntarily? And did you plead true to those allegations because they're all actually true? In each of these cases, I also have some documents here on the computer that have your signature on them that the state's marked as Exhibit Number 1. Did you also go over all of these with Mr. Rennick?
Yes, ma'am.
And you fully understand them? And it looks like the agreement in all of these is for me to continue you on probation and order that you enter and successfully complete the ISF cognitive track. Is that your understanding? State tenders number 1.
There's no objection.
It's admitted. Is there any evidence again that Mr. Henderson's not competent?
No, Your Honor.
All right, Mr. Henderson, in each of these cases, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty in 2 of the cases and revoke your probation, and then revoke your probation in the other case. But I'm not going to do that. I'm going to reset your cases for an updated pre-sentence report, and then we'll come back at a later date to see if I'm going to accept these plea agreements or not. I do have some current concerns, obviously. I'm sure y'all know. I mean, we've got 2 felony probations from 2022, and then that theft, was that committed while he was on probation?
It was
From prior?
prior. He had stolen the dirt bike, I believe, Judge. And that's what always revolved the dirt bike.
But one of them wasn't indicted till much later? So we've got the 2 cases, the evading arrest and the unauthorized use of a vehicle. Those are both from 2022. Then we've got a theft of property from 2023 that he was put on a straight probation for. So we'll get it all figured out with the pre-sentence report, but it looks like,
That was a tailgate that was stolen from Ranger Chevrolet in Orange, but he helped in recovering that.
so he was on,
It was
So-
indicted later.
but it was an offense, when was the offense date?
I thought the one that was
That would be 23, I mean, well, no, that's the indictment date.
February 2nd of 23.
Okay, so on 2 felony probations, committed another felony, got an opportunity, now we have another felony. So I want to see what all's been going on before I accept these plea agreements. I can tell you one thing that you are doing good and that I hope you continue to do, unlike everybody else probably around you and wherever you are, whichever dorm you're in, is I don't have any incident reports. On paper, it does not look like I should give you this opportunity. If you continue to do well, you have a much better chance of me going along with what they've proposed to me to do, all right? Okay, go back with the,
One thing before we go.
Yes.
To his credit, we're actually here to make arguments. He's acknowledged to me the entire time, he realizes that he is not done what he's supposed to be doing. He's been very upfront with me about he wants to change his ways. So
thank you, I appreciate that.
there's something there.
Okay, we'll see you back at sentencing. Thank you for letting us know.
Good. So I don't like to.
All right, sir, let's see, Ms. Malfino, this is Aleem St. Clair.
Sorry, Judge.
That's okay. Good morning, sir. Are you Aleem St. Clair?
Yeah, ma'am.
Are you sick?
A little bit, ma'am.
What's wrong with you?
Had a little fever.
When?
Like 2 days ago.
Okay. Like you're, all right. So, Mr. St. Clair, in cause number 23, DCCR
Should be 4 cases.
1390, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2023. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 23, 2117, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand that as well?
Yes, ma'am.
And then in cause number 23-2044, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. Again, that has the same punishment range if you're found guilty, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 23-2043, you're charged with unauthorized use of a vehicle, which is a state jail felony offense. And that is from July 11th of 2023. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
In each of these cases, I have here on the computer some plea bargain rejections that you have signed with Mr. West that shows that the district attorney's office has made an offer. So is it, what's the?
It would be a 25-year cap in both of the aggravated robberies. We had offered or discussed to dismiss that aggravated assault based on a plea in those ag robberies, as well as the UUMB. We rejected that. We went ahead and did a rejection of the 20 cap in the aggravated assault. But it was my original position to dismiss two, and if he would accept responsibility in the 2 aggravated robberies, and also not to proceed on his 3 misdemeanors. If I may, just for the record, so Mr. St. Clair is aware, now that he has rejected this, unless circumstances change, which I'll bring to the court's attention well in advance, it will be my position to ask that the sentences run consecutively.
So, Mr. St. Clair, I want to make sure you understand. It looks like what you have signed with Mr. West shows that the state's offer was for you if you wanted to enter a plea of guilty to the aggravated robberies for a cap of 25 years, which means you would be leaving your punishment up to me. I could sentence you to 25. I could sentence you to less. It would depend on the information that was brought to me at a sentencing hearing. And the agreement would have been to dismiss the unauthorized use case, as well as that aggravated assault case, as well as some misdemeanors. If you go forward with trial on these cases, we'll go depending on how this all goes, because the offense dates from the aggravated robberies and they're to the same dates, but then that aggravated assault and the unauthorized use are from a different date. What that means is that if you're convicted on those cases and sentenced by a jury, I could then stack those punishments on top of each other. And I don't know if I would do that or not. It would depend on the information that I saw during those trials. Do you understand?
Yes, ma'am.
Do you want to reject those offers and have all 4 of your cases set for trial?
Yes, ma'am. I'm trying to get a lower offer.
Pull that down a little bit.
I said I'm trying to get a lower offer.
So here's the thing, we're not negotiating anymore, okay? The offer, Ms. Malfino just stated that the offer is what the offer is, and unless there is some new information that is received after today, I will not accept this offer after today. So today's the day to either accept this offer, or your cases will go to trial, or it will be to some offer that's different, higher, or to me open, unless there is some, again, new information that no one knows about. And is there any reason to think there would be any new information?
No, Judge, and what my position was in offering the cap that Mr. West and I discussed was to allow Mr. St. Clair to ask the court for probation. I think that's what he's trying to say. That's what he's been trying to say through his attorney. I'm not in the position to offer that. He's been in custody for some time. I think it's been explained to him that the court would take a look at everything and make a determination, but it's not my intention to offer probation, although I'm very well aware of the fact that the court could place him on probation. If that's what the court does, we'll respect that decision.
So you understand, if you plead to a cap, I can do, again, anything from probation up to 25 years in prison. I know nothing about your cases at this point. So I don't want to give you some false sense of, yeah, plea open to me and you're going to get a probation. I don't know. You could plea open or cap at 25 and I could give you the 25. I could give you somewhere in between. I can consider probation. I just can't know those things but right now because I don't have any information. And if you did that, what would happen is if you wanted to enter a plea and take that deal, then we would reset your cases for sentencing. We would get
I ain't doing this shit I did, no.
Well, if you didn't do it, that's what a jury's for. So we'll get them set for trial, okay? All right, go back with the bailiff. We'll get them set for trial. Good morning. Are you Matthew Wadsworth? And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, this is a cap of 8, the agreement, I think is a cap of 8, and just based on the criminal history alone in the PSI, it looks like.
It looks like you did a very good job of getting that agreement.
That's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history, the first page of his, or I guess, rolling into this second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000, all one, in January 2002. They all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case, he's
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. And he understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he was pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. I can phone off. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight F's, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin, I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something, and I hope it don't hurt you, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on. But in my head, our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. When we started fighting, I was losing, and I hit him. If you do give me the chance, what I need is some help staying on my meds, because I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or if it's, I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Yes, ma'am.
The problem is, you're 51 now, 52?
51, ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said, this
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions, 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith?
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's
That was my
pending.
last one.
Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account to probation, where he said the part about the baseball bat is not true. A dresser fell on top of
I saw that.
it. He's still not accepting
I
responsibility.
hit him with the cane.
Hold on, don't
I'm
speak
sorry.
over. I let you talk, so
I'm
don't talk
sorry.
over anyone else,
I'm so
please.
sorry.
I believe probation is absolutely right, that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence, TDC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement, because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. Try again, same number. Good morning, are you Prestavian Westbrook? And will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Westbrook, in cause number 25, DCCR 0101, you're charged with the state jail felony offense of theft of a firearm, and that is from November 15th of 2024. And how do you plead to that charge? Are you guilty or not guilty? Well, there's no I guess guilty. Did you do it or did you not do it?
When we say stole it, I ain't steal nothing.
Okay. Were you with some people who stole it?
No, man.
Your Honor, he bought a gun that the police checked and the gun came back as stolen.
Okay.
The probable cause, I'm sorry to step on you, but the probable cause affidavit represents that the defendant indicated to law enforcement that he had some knowledge that it was stolen.
Let me look at that real quick. So did you know it was stolen?
No,
The
man.
gun was stolen in 2015, in which he would have been 8 years old. So he did buy the gun off the street. I mean, I guess you can feel like it might be stolen, but he was 8 years old when in Hardin County. So clearly he's not the one that stole it. But it's indicted as if, he appropriated the property with the knowledge that it could have been stolen, and that's what he was indicted on.
That's the state's position.
So what you told the police was that you bought it for $250 and that you believed it was stolen because that's what other people had told you. Is that right? Okay, so if you didn't know it was, if you didn't know it was stolen, if no one told you it was stolen, obviously you didn't steal it because of the dates of all of that, but if you didn't know anything about it and you were just buying a gun illegally, that doesn't mean that you should plead guilty to theft of a firearm. So I want you to be careful what you say today, because when you were standing over there in front of the clerk, you put your hand up and you swore to tell the truth. And so you can't say, I just want to take this deal and get out of jail, but then stand up and say, I didn't do it. If you didn't do it and you didn't know, then that's what trials are for, and a jury can decide if you either did it or you didn't do it. But if you're in front of me and you want to take this plea agreement, it's going to be because you actually knew what was going on. So you either did or you didn't. Do you want to talk to Ms. Holmes for a minute?
Yeah.
Okay, y'all go visit for another minute. Just for a minute though. Let's see, you also have, let's take care of, all right, sir, you're Daniel Martin.
Yes, ma'am.
And, let me get this pulled up. Hold on a second.
Judge, with the court's permission, may we proceed on count one only on third degree harassment?
Yes, ma'am. Okay. And that's 0299, correct?
Yes, sir.
Okay, so Mr. Martin, in cause number 250299, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of harassment of a public servant from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in cause number 250300, you're charged, and we're going on all of them in that, we're going on,
Is that the state jail?
yeah.
He's playing a 2-year state jail. I don't
So
know.
it's state jail only and not the
Yeah.
priors in that one?
Oh, I see what you mean, Judge, the priors would make him.
Second degree.
On that, that's my error, I didn't flip the page.
That's okay.
Over, I was just
So-
looking at the restitution.
Count one only?
If the court would allow, if not, I'm happy to.
Well, I guess I'll see what happens at sentencing. I mean, what's the
It's a time
agreement?
off.
It's a
2
time
years
offer,
state jail.
2 4-year state jail.
Oh,
It's 2 years on that one and 4 years on the other one.
and the other one, he would be habitual. Okay.
If
but-
I need to revisit the offer,
No,
Judge, that's
no, no, no,
that's
no,
my
no,
mistake.
no, I just need to make sure I'm doing it right. I'm sure, I mean, unless you want to revisit it, if you've looked at it and you know what the cases are about, if you're comfortable with going forward with that, that's fine with me.
I am, Judge, if the court is.
Okay.
I think insurance took care of the restitution issues.
Okay, so in 250300, the state's also elected to proceed on count one only. In that case, you're charged with the state jail felony offense of criminal mischief from August 29th of 2024. And how do you plead to that charge?
Guilty?
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I'm sorry.
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am. I do.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Martin is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of those pleas. In cause number 250299, find sufficient evidence to find you guilty, and at this time find you guilty of harassment of a public servant. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 250300, also find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes.
Yes, ma'am.
Good luck to you, sir. You can go back with the bailiff. So we're back on the record with Mr. Westbrook, and you had a minute to talk to Ms. Holmes. Ms. Holmes, what's the position?
We'll move forward with the plea.
Okay, so Mr. Westbrook, you were able to talk some more with Ms. Holmes about the law, and so I'm going to ask you the same questions that I asked you a minute ago, okay? You already entered your plea of guilty. Did you do that freely and voluntarily?
Yes, ma'am.
And did you do that because you did what they charged you with? Okay. I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you understand those papers?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I say yes or no, please, for
Yes,
the,
ma'am.
that's okay. And so it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation, no fine.
There actually was a $1,000 fine.
Oh, I'm sorry. I
There
didn't
typically is.
put it on there.
How much, 500?
It was 1,000, Judge.
There would be,
I'll
how old are you?
500. I'll amend my offer to a $500 fine.
So there would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Westbrook is not competent?
No, Your Honor.
Is there any other history? Obviously, he's young. Anything that you
Judge,
see?
none as an adult that's reflected in my file. There was a 2023 assault as a juvenile, but other than that, that's all the criminal history I have.
Did you get probation when you were a juvenile? What happened on that
There was a
case?
fight at school.
It was. What happened on it because of it? Did you get in some trouble?
I went to juvenile to Minnie Rogers.
Right.
But, I don't even think he was that long. I think he was like a day or 2.
Right. And then when you got out, did you have to do any kind of probation or anything like that? Okay. Any opposition to me waiving the pre-sentence report?
No, Your Honor.
Okay. Mr. Westbrook, I'm going to again find you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. You understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, but I'm not going to do that. I'm going to defer all proceedings, place you on probation for a period of 5 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation. If you do that, this is such a great opportunity for you because you don't have a felony conviction on your record. All right, and if you successfully complete this probation, at the end, the case will be dismissed. You will never be a convicted felon. Part of this probation is going to be that you are not allowed to possess a firearm. There is no reason for you to be out on the streets buying guns, because all that's going to lead to is you being in here for something a whole lot more serious. So you're young. Now's the time to direct your life in a whole different way. If you don't like it out there in jail, then stay out by doing what you're supposed to. If you're hanging around with people that are messing with guns and all that, stop doing it. Go to work or go to school, go home, live your life so you can live it like the rest of us. Because here's what can happen. If you violate any condition of probation, you don't follow the rules, you test positive for drugs, you don't show up for your appointments, you get another case, whatever it is, you can be brought back into court. You would be found guilty, so then you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am.
All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Another thing that's important for you to know, Mr. Westbrook, is if you get out there and you do your probation all right at the very beginning, get that community service done, get your fees to take care of everything early. I sign early terminations for probation all the time. Every day I'm signing them. But the only ones that I sign to get off probation early are those who've done everything they're supposed to. All right, so we are back on the record in cause number 2137857. And again, you're Jacqueline Young, right? And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the,
The new agreement is 8 years TDC.
all right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, Your Honor.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them, that the state's marked as exhibit number 1. And before you signed these, did you go over them with Mr. Lewis? Speak up. And do you fully understand them also? And I have made the notation with everyone's agreement on the agreed punishment recommendation page that that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank
All
you.
right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with this agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct?
Yeah.
Okay. It can still go worse. I mean, I got 2 more years. It's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself, you know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before. All right, good luck to you. You can go back with the bailiff. Good morning. Are you Xavier Garner?
Yes, ma'am.
And Mr. Garner has 4 cases, and 230957, harassment by a person in a correctional facility, 242322, aggravated sexual assault of a child, 242323, and 2324, indecency with a child. And Mr. Matuska, what is the announcement?
Your Honor, I've been able to collect most of the discovery. Still trying to get some of the digital media. I do expect this case to be placed on the trial docket. I just need to get the digital media.
Okay.
I've talked to Mr. Nichols about that, and that should be shortly.
We did speak, Your Honor, but I've been out the last few days, so I wasn't able to get that resolved for him this time around.
Okay.
I think it shouldn't be hard to get it for him, make sure he has everything.
Okay, so I'll do one more reset, and this will be the last reset. Y'all make sure you visit about all of that. Mr. Garner, what I have here is a pile of jail incident reports. So I want you to make sure you know that I know everything you're doing in court. And if this goes to trial, a jury will know everything that you're doing in our jail. Do you understand that?
Yes, ma'am.
You're fighting, you are talking back in an extremely ugly way to the correctional officers who are just there trying to do their job. That's their job. They're just going to work every day. They don't need to hear this crap from you every day. Every single day you're talking back, you're calling names, you're not following the rules. You want to do it your way. When you're in jail, you don't get to do it your way. And if you do continue to do it your way, you're going to end up with another harassment of a public servant in a correctional facility. You're going to end up with more time if you get found guilty because a jury's going to.
And that brings us to the end of a courtroom session filled with tough decisions, second chances, and some serious consequences. We saw defendants receive prison time, probation opportunities, and warnings that their next mistake could completely change the outcome. But the biggest takeaway is simple. A plea deal may offer a path forward, but what happens after that is ultimately up to the defendant. So, what do you think? Did the judges get these sentences right? Or should some of these defendants have received a different outcome? Let us know your thoughts in the comments, and if you want more real courtroom breakdowns, make sure to like, subscribe, and stay tuned for the next case.